Well, hello, everybody. This is Zoom Landlord Tenant Radio, another edition every Saturday at 3 p.m. And as you can see, I'm in a different location now. I am actually sitting in my business office as opposed to my home office. And my office building is located in Burbank. And I'm doing it here today because I'm going to have to skedaddle right after this Zoom meeting and go to a Laker game. So it's a little bit closer here than in any other place. I wanted to just briefly talk about a couple of things because I do want to open it up to questions since I might be ending this a little earlier. And that deals with a couple of things. Number one, please put on your calendars that this coming Wednesday, that would be March 20th, there is an all-day trade show sponsored by the Apartment Owners Association. That's going to be at the Los Angeles Convention Center. I implore you to go down there, especially if you've never done it. You're going to see so many vendors that will teach you how to operate your buildings, insurance, from contractors to vendors of appliances. There'll be plenty of legal people there like myself, and there'll be all-day seminars that you can go in. And the cost, ladies and gentlemen, is free. There is no charge. So definitely make your plans to come on down there. I'm actually going to be speaking at 1:15 in the afternoon. I'm going to be in the room Seminar A, and I have a booth there as well, so you can come up and actually say hello to me. And we'll have attorneys in the booth. I'm having two attorneys in the booth, and one of them actually shares my name. That would be Madison Block, my daughter. She'll be there. She's an attorney. You'll get to meet her, and then you can then obviously stay for the presentation that I'll be giving. I'll also be giving out a bunch of handouts, which will help you in terms of operating your buildings and trying to stay up with the laws. The other thing I wanted to talk about just briefly is the issue of people breaking into your vacant units. This is becoming more prevalent, and lately we had a law passed in Florida, which finally came to some common sense that you don't have to go through an eviction case to evict these people who are merely just trespassers, but always produce a phony lease. That's what they do. They produce a phony lease, and then we're stuck having to go forward with an eviction action. So Florida, the progressive, intelligent place that believes in property rights, passed a law that says that if the landlord, unless they have the landlord's signature on a rental agreement, then the police are instructed to immediately remove the trespasser from the unit. It does allow the person being removed to bring forth a lawsuit against the landlord if, in fact, the landlord was just using this as a guise to get rid of a tenant. But I don't really see that happening often. What's happening more often is that tenants are just breaking into units, setting up house, and then immediately will show some lease that they got online. For you people that have a vacant unit, I can't tell you enough to secure that unit, put on signs saying no trespassing. You might want to even put an alarm on it, which is backed up to a security company, so that if anybody does break in, you'll get immediate notice of that, and it'll be very easy to get rid of the tenant in that situation. But barring that, ladies and gentlemen, you need to make sure that you are good in terms of securing your properties. In any event, I think we should move on from this point because we're going to end it a little bit quicker here. I do appreciate everybody jumping in. Some of the ground rules, of course, are that if you have a specific case with me, please do not discuss that case. We're only going to talk about general issues dealing with landlord-tenant law. This Zoom meeting is for informational purposes only. It is not a substitute for getting legal help. If you do need to ask a question, I am happy to answer it. We want you to electronically raise your hand, and I will then call on you. Otherwise, please keep yourself muted. And we're going to take our first caller of the day, our old-time favorite listener, and that would be Dina. Dina, I'm going to ask you to unmute yourself.
Yeah, hi, Dennis. Thanks a lot for doing this again. And today I have a question which is regarding holding deposit. And the term is because I saw on the LA County website they allow that, but then they ask for a receipt. And my question is that to hold when you have a tenant and they are giving like a notice to their old a landlord in order to get into the unit. So you have this gap of time. And is it only we hold the deposit that we're asking with the rent, or we hold the rent and the deposit? And can we do it and then later, sign the lease? All these things are like, and no, to me, I mean, I don't know anything about.
Okay, well, what you're talking about is that when you're planning on leasing a unit, you want to gather the applications and run credit checks, and you can ask the tenant for what they call a holding deposit, which you'll hold for them. And then if in fact they are granted the privilege of moving into your building, then that deposit will be applied towards the security deposit. Now, a lot of times a tenant, after they've approved, will then say, you know what, I've changed my mind. I don't want this unit. So in that situation, unless you have something in writing, you're going to need to give him back that deposit because you haven't signed a rental agreement and he hasn't signed a rental agreement. I do have that form on my website at evict123.com. And on that form, it states that if we choose you, then, and you choose not to, then you're going to have to give us, allow us to keep 50% of that deposit. So you might want to check out that form, Dina. And
because I went on your website, but maybe it has another name, Dennis. What do you
I'd have to go back and check on it, but it should be called holding deposit because I do have it there. I've seen it not too long. So just go through all of them, but you should see it there.
Okay, we'll do that. Thank you so much.
You take care, Dina. And we are going to now move on to Greg. Greg, I'm going to ask you to unmute yourself and say hello.
Hey, Dennis. I have a question, and if I have a chance, a cautionary tale. But the question is, my tenants, because it rains so much, I have an exposed beam roof, and just on the areas where the beams hang down, and it's just wood up there, and then above that would be the roof. There's like a little bit of mildew, and they're freaking out, and they want mold tests. But I mean, I'm 99.9% sure when I walked in there, it's all closed and kind of just stuffy. I'm pretty sure that's what it is, but would you recommend that I get the mold test just to be on the safe side?
Is this inside their unit or outside their unit?
It's inside their unit, right by where there's like a big door that I don't think they really open very much, and it's right just like I have wood exposed, and above that's the roof, and it's right on the edges, the beams that support the roof that hang down like that, and there's like these tongue and groove pieces of wood right there on a couple of those beams. There's some mildew.
I would probably recommend that you do get a mold test at that point. There might be some water leak coming in somewhere, and that should be addressed. So definitely, yeah, I would treat it and make sure that it is dried.
Can I tell you the cautionary tale that I just got blasted by from the city of LA?
Go ahead. I'd love to hear it.
I think this is a new one for, yeah, because when I used to hear you talk about stuff and the other attorneys, I thought you guys were like kind of crazy, but we have a property in the city of LA in Palms that's on a 50 by 150 lot. Like the houses, it's all houses, duplexes, and we had the biggest property on the block. But there's a vacant lot that like it's been vacant for a while, and I just got a notice, and the city of LA sent it to me and all my tenants that on that tiny little road that only has parking on one side, they're going to develop a 7-story, 72 unit multifamily property that's 100% low income housing. And the kicker is the notice says that if we appeal legally, there's an indemnity clause that if we appeal and we lose the appeal, we have to pay for the district attorney's fees and the developer's fees to defend the case. So it's pretty much shoved down our throat, no appeals allowed. And again, this is a place that has single family homes. We had probably one of the bigger, it's a 9-unit building, a 2-story building there, and duplexes. And they're going to just completely destroy the neighborhood. And it's in like,
I wouldn't take the cautionary admonishment by the city as truth. I think the neighbors should all band together. And I think they should write, this is in the city of Los Angeles, correct? You said
yeah,
Palms?
and Yaroslavsky's our wonderful city representative.
I think you guys should all get together, and I would start lobbying that particular council person. I would also engage the services of an attorney. My firm doesn't handle this area of law, but I would certainly, between, 40, 50 people, it's not going to be that expensive to hire an attorney who will at least go through this and see what your possibilities are. So I would do a 2-pronged attack. One, hit your city councilman, in waves of stuff, and see what he can do for you. And at the same time, engage the services of an attorney who handles that area of law.
Okay. And just so they said that this is done because of the housing emergency by Karen Bass. And I've seen Miss Yaroslavsky has done it in other areas in that area, but I will try and see what we can do.
Yes, definitely band together.
All right. Thank you.
Greg, thank you very much. Have a pleasant day. And I am now moving on to, let's move on to Leonard. Leonard, unmute yourself. Leonard's a regular.
That is correct. Hi, Dennis. How are you?
I am fine, thank you.
Good. Just curious, if a tenant represents herself pro per, it comes to court and then says to the judge, "Oh, I need an attorney," and then could she then extend this case and keep extending it out, or how does that work in terms of?
No, courts aren't going to extend it for that reason. They would have said you had plenty of opportunity to get an attorney, and there's plenty of free attorneys around, so they wouldn't extend it for that reason.
Oh, they wouldn't. Okay.
No.
All right. Thank you.
Okay. Ira I, or is that L? Ira I, I'm going to ask you to unmute yourself.
Hello.
Hi there.
Hi. I have a couple questions. They not very, I think, difficult. So the first one, I have a 3-bedroom single family house and grandpa unit in the back in an incorporated area, LA County. Both units have the same address and share utility meters. So I never rent the back house because I keep it for myself as a storage room. And, when I do repairs, when I have some, project going, so it's my storage. So the question is, right now I pay all the utilities, accounts on my name. So when people move in, I don't have any tenants right now at all. So if I rent a big house, it's 3 bedrooms, which is separated from the back unit. So the people want probably to have accounts on their name. But then will I use my right to use the back house, my storage?
Okay, well, you're not planning on moving into this rear house, are you? You're just using it for storage?
No, it's just a storage. I come only when I repair, when people move in, move out, or I meet like a handyman or some emergencies. So nobody there.
Exactly. Now, is that a legal unit?
Well, that's an original unit, what was built in 50s. And then later, other owner, they built, I believe in like 1969, this 3-bedroom. So that one is a totally like 1-bedroom house, but it's not, it wasn't finished all their, what it's called, permits to do it. So it's never been rented.
Right, that's the easy way to say it. Yes, that's an illegal unit, but if you're not renting it, then there's really no problem. I would just put into the rental agreement that you're reserving the right to use that back unit, and that is not part of the tenancy. I would also put into the rental agreement that there is only 1 meter and that there will be some usage from time to time that I would be able to use the electricity but that you're going to bear all the cost of that. And I
Okay,
just
so-
put that in the rental agreement. As long as you spell it out that there's only 1 meter, that you're reserving the right to use that rear house, that's not part of the tenancy, but the tenant would be paying for all the utilities for both units. As long as you put it in your rental agreement, you're fine.
But they might be afraid that say, oh, why should we pay for your unit? Even I'm not there. I'm only when people move in, move out.
Right. Well, then explain the story to them, and if they don't like your position, then tell them not to rent from you. But if they want the place, then that's the terms of the rental agreement.
Okay, one short question about deposit. So can I mean, am I allowed to increase the security deposit for existing tenants when the annual rent increase is due, so the deposit match the new rent price?
You can raise the rent for the city of Los Angeles. You are allowed to raise the security deposit the same percentage that the rent is being raised.
But this is a city with RCO and just cause.
So it's a JCO. In other words, you're not under the rent stabilization, you're just under just cause.
No, 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 it's another property. That property is under RCO, city RCO and just cause. It's a
Okay,
Lake
so
County.
then, just as I said, under RCO or RSO, you're allowed to, that's the rent stabilization ordinance, ladies and gentlemen.
Yes.
You're allowed to raise the security deposit the same rate as you're raising the rents, and it's supposed to be at the same time. So if you raise the rent 4%, you can do a 4% rent increase on your, or
But I
4%
cannot,
your
yeah, but I
security.
cannot increase right now to double deposit for existing tenants, what I have now.
No,
cannot-
that is verboten by the city of Los Angeles.
Is that a form for that?
Is there a form? It would just be a change of terms of tenants.
Okay, thank you very much.
All right, you take care. And we are going to move on now to Chris Landis. Chris Landis, I'm going to ask you to unmute yourself and say hello.
Hey, how you doing? Two quick questions. The first one is about giving notices in a large apartment building. I saw your video about notices to enter. If there are a lot of units, can I just put a notice up there that says, you know, this week between the hours of 9 to 5, you know, we're going to be coming in and changing air conditioner filters, for example, like without instead of just giving a specific date and time?
I would give a specific date and you can say for the day from 9 to 5, we'll be entering your units for the purpose of changing, you know, air filters. But I would put it on every tenant's door. I wouldn't put it in a general location.
No, but can you put it like for the week? Because you can't do them all in one day. Like, can I put like, you know, Monday through Friday from 9 to 5 will be coming in?
Yeah, I think you got to be more specific. So you tell your contractor that, hey, you've got to figure out how many units you're going to do on this date and how many you're going to do on that date. I think it should just be done like that.
Okay. Then the second question is if, you know, I want to evict someone who owes back rent for COVID. They're saying they had an application for COVID. They've got a thing from, you know, one of the rent relief places. Does that preclude me from trying to evict them?
Are we talking about the city of Los Angeles?
City of Los Angeles.
Okay, so the city of Los Angeles states that if they have applied for this ERAP, this eviction rent assistance program, if they've applied between September 19, 2023 and October 31st, 2023, if they have applied for that period and they have rent that was accumulated between October 2021 and January 2023, that you cannot commence an eviction for that period of rent owed. If they have filed that application, they've been approved, you'd have to wait until at least May 31st before bringing forth an eviction.
Okay, and why is that that I have to wait?
Because the city of Los Angeles has has ordained an ordinance. And it's new section 165.11. I'm cheating because I'm looking at it to my right here. But that's part of the eviction protection while tenants are waiting for disbursements from the ERAP program.
Okay, and what if they get denied?
Then as soon as they get denied, you could go, you don't have to wait till May 31st.
Okay, great. Thank you.
All right, you take
Bye.
care. Okay, let's see, that was Chris we were talking to. And let's move on to Jim Polina. Polina, I'm going to ask you to unmute yourself, young sir.
Okay, can you hear me okay?
I can. Love the background.
Thank you. I'm calling on behalf of a friend. She lives in the city of LA, RSO, single family residence with no other rental units. She's been there for 20 plus years. She's over 65 and she's deemed handicapped. Can the landlady evict her?
This is a single family home in the city of Los Angeles. Every residential unit, regardless of how new the unit is or what type of a unit or who the tenant is, you need to have good cause to evict now. So they'd have to have some reason to evict.
Okay, so the landlady wants to double her rent, or I think triple her rent, actually. She is far below market, and the landlady wants to triple it, and so my friend is really stressing.
Yeah, that's different than asking her to move to triple the rent. Okay?
Right.
But the law states that you can triple the rent for a single family residence. You can bring it up to market value. If you're going above 10%, then they would need to serve a 90-day notice. And this doesn't matter how old she is or infirm she is or how long she's been there.
Right.
Under the Costa-Hawkins rule, she has the right to raise for a single family residence with only one house on the lot. She has the right to raise it to market level.
Now, I thought a state of emergency would preclude that until it's over, which I think is August.
I'm not aware of a state of emergency. Maybe the governor declared one because of the last rain? Is that what you're referring to?
It's for LA County, I think it is.
Yeah, if that's the case, and I wasn't sure whether he did that or not, but there is some crazy law that says that if there's a state of emergency, then you can't do a rent increase in excess of 10% unless you can prove by your costs and expenses that was not gouging, so to speak. So the owner in that situation, since it's so far below market value, based on his expenses, might be able to prove that. Otherwise, you're going to have to wait for the state of emergency to be declared over.
Okay, thank you very much.
You have a good day, sir. Okay, we are moving on to Sonia. Sonia, I'm going to ask you to unmute yourself.
Hi, Dennis.
Hello.
Hi. My question, excuse me, is about reasonable cleaning fees. A tenant that moved out, and usually we have these same people come in and clean. Now, this tenant actually was very good. He didn't use it too heavy, but our cleaners still need to come in and do everything, and they're going to charge us the full amount. My question is like, is it still fair to withhold their full fee, or because it wasn't as bad, should we just reduce it, only take away half? Or what's your opinion on reasonable cleaning fees?
The law states that it's what it actually and reasonably costs you to clean the unit. If you have to hire a service to go in there, the service obviously will adjust their fees based on how much they have to clean. But whatever that reasonably costs you is what you can charge the tenant.
Okay, so it doesn't matter if he was cleaner than other ones, we still have to go in
Well,
and do
then
it.
I think though, think about your cleaning service should charge less because there's less work, right? One could make an argument. But
True.
if the tenants, even though they left it really clean, they don't clean inside the ovens, they don't clean the inside the contents of the refrigerators and that kind of stuff. So you do need to
Yes.
do your cleaning. I would imagine some cleaning services just have a set rate. For a 2-bedroom, we charge this. For a 3-bedroom, we charge that. But that's what it actually costs you. You can submit when you do the security deposit itemization, submit the invoice.
Okay, great. Thank you so much.
Thank you. Good question. Okay. This is going to be, I think, maybe two people. George, Ann, I'm going to ask you to unmute yourselves. Are you there?
There you
George?
go. Do you
There
hear
you go.
me?
I
Yes.
can. I think you got to adjust
Wonderful.
your camera a little bit. Oh, I
I
don't
know
see
it's
now.
strange. I tried, I was here last week and I couldn't see you, so now I can.
Well, that's good.
Thank
Oh,
you so much
Georgie Ann.
for
Okay, I
everything
got
you
it now.
do. I really appreciate what you guys do and what you do specifically. My dilemma is that I may have to sell the house that I'm living in, which is not my tenant's house, obviously, and move into the rental house, which is in LA County unincorporated.
Good luck.
Oh, really?
Yeah, they're the
Well,
worst.
he has a lease, and if I have to give him 60 days notice, right? He's been
To
a good,
vacate?
well, his lease is over on June 2nd.
Well, his
So,
lease might be over on June 2nd, but he gets to stay there for until you have cause to evict. Cause to evict would be that you are going to want to occupy the property. You're going to have
Right.
to pay substantial relocation. Let me look that up.
I am gonna have to do that?
Substantial relocation.
Oh, God.
And how many bedrooms?
One.
And is he a senior?
No,
Does he have children?
no.
$8,662 is what I'm seeing here. But it gets worse than that. First of all, we have to file an application process with the city. But there's something else which is insane that only unincorporated areas of LA County require, and that is you have to hire a relocation specialist.
Has that gone through now?
Oh, that's
definitely-
gone through. Oh my God. First of all, it's impossible to find one. We finally found one. And what was their name? Do I have it here? Relo Company right
My
there.
God.
It's called LACAL, LACAL Consulting. It's the only one we could find. Once again, the first word is LACAL, LACAL Consulting. They're located in Alhambra.
Okay.
You can watch the replay of this, which I'll be doing the replay tomorrow, not today, since I'm going to the game. But their phone number is 951-9887, extension 101. You have to hire this company. They basically are charging around $3,000. And then and it's based on a retainer and an hourly. This is just so that they can give your tenant counseling on how to find another place. It's insane with the county to move into your own unit. It's probably better to make a deal with your tenant where you just walk over to them and say, hey, I want to move in and I'm willing to give you X amount of dollars if you move out. Okay.
Right.
Now, nothing prevents you, since this is a single family residence, from raising the rent. So
Well, that's what I was wondering. He's been in there 3 years. How many, can I only raise the rent 10%?
no, you can it's a single family home. You can raise the rent to as much as you like. I happen to have a program here. Well, actually, I don't want you to say the address. I don't want you to say the address. Otherwise, I'd look it up
Okay,
for privacy reasons. But
right.
you can go to Rent-O-Meter. That's RENT, the letter O, meter, METER. So rentometer.com. And it's free for the first 5 times. You can put your address in. You can see what other units, single family homes within a very close proximity of your property is renting for. So you can raise the rent. If you're going to go above 10%, you're going to need to serve a 90-day notice.
Okay,
So you might want to try offering him some money to move. Otherwise, tell him that I'm going to have to give you a rent increase.
right.
I would probably not mention that you want to move in. So
Oh,
tell
you
him, look,
wouldn't? Oh,
no, tell him,
okay.
I'm thinking of renovating, I'm thinking of selling, I'm thinking of doing something. So I'll give you X amount of dollars to move if that makes you happy. Otherwise, I'm just going to have to raise your rent. And then you can show them the rent comparisons that you're going to get from that Rent-O-Meter. And that might persuade him to move.
Now, because he has a lease and it's over on June 2nd,
Yeah, you have to
Is-
wait till June 2nd. He's golden until June 2nd, but on June 2nd, it becomes a month-to-month tenancy, but you just can't say your lease is over, get out. That's not how it works.
I can't say that I have to move in, I have nowhere to live.
You
and
can,
blah,
but then
blah,
you're
blah.
gonna have to pay the relocation
Oh,
money.
I see. Okay.
And you're gonna have to pay to that consulting company.
Oh my
So,
God. How do they
yeah,
get
that's,
away with this? I just don't, I don't understand
well,
how
there's
that.
there's no belief in property rights in this, at least in this county. And basically in the state of California, that's why everybody's getting out of Dodge, you know?
Well,
So,
if I wanna, the other thing is, I may be forced to sell that house. And that's gonna be
and you're
another,
gonna sell it with that tenant there because you can't ask a tenant to move because you're selling. That's not a ground to ask a tenant to move. So the new owner's gonna have to deal with this.
that is outrageous. I mean, how does that, I mean, how do we get by if we have to sell a home?
It's
There's
very,
no
it's
legal.
very simple. Vote conservative on everything you do, and every time it says the word bond on your ballot, say no.
Okay. But so the leases really don't mean anything anymore. I have a really good lease and.
You have a really good lease, but the problem is that the state of California is telling you what you can do with your own property and also unincorporated areas of LA County. Anyway, thank you very much. I am going to move on. Let's move on to Duke. Duke, I'm going to ask you to unmute yourself.
Hi, sir. Thank you. We have a single family home in Santa Ana, and the rooms we rent out to individual people. There's just one tenant that she has not paid her rent yet, and every single month it's been a headache. She's been staying here for 2 years plus. I just don't know what's the rule on pay 3 days or quit. Is that the same if you rented individual rooms instead of the whole house?
Okay, so this is just one room that you rented, correct?
Yes, it's a single family house that we rent out individually to people. We are not living there. It's all
Got it.
our
And
tenants in that house.
what city, please, again?
Santa Ana, Orange County.
Santa Ana has rent control. They might frown. I'm not sure about this, but Santa Ana does have rent control and they might frown on renting out rooms. You might want to check with them. However, notwithstanding that, you have the right to demand your rent. So if this one tenant in this one room is not paying rent, serve a 3-day notice and proceed forward with an eviction. The city of Santa Ana has certain things that have to be attached to your 3-day notice. There's also forms that need to be posted on the property for the city of Santa Ana. So make sure that you comply with those rules.
I tried reaching out to your office. I called and several times last week, but no one has gotten back to me. Is there any way for me to connect with you directly to engage your services?
I always tell people if you want to reach me personally, just call between 7 to 8 a.m. and hit my extension, which is 1001. You can only use that extension between 7 to 8, otherwise I will violently hang the phone up. But between 7 to 8, Monday through Friday, you'll get me without a wait. And we do have a lot of phone calls coming in, but happy to assist you. So you'll get me on Monday morning.
Okay. Thank you so much,
And
sir.
either I'll be in a good mood because the Lakers won today, or I'll be in a bad mood, but one of the two.
Okay, but the same rule applies whether there's renting the whole single family or individual room.
Correct. All right.
Okay.
Thank you, Duke. We'll talk
Thank you.
maybe on Monday.
Definitely.
And we're going to move on to, and if you got questions, I see I might be running out. So, because there's a good day to do it. Garber, I'm going to ask you to unmute yourself and say hello. Garber, are you there? Well, Garber, I am going to move on then let's move on to Lenska Bracknell. Please unmute yourself. There you go.
Hello. Hello,
Hi.
Dennis.
Hello.
Thank you for all you do. I have a question regarding on the safety for a tenant. I have an unit complex in the city of San Diego. And I have a property manager slash maintenance man who was accused that he ran a tenant across the parking lot with a drill. Now she claims she can't feel safe. She can't get out of the unit, and he had to do some other work, and she called the police again, but the police, there was no report filed. Since we're in the middle of installing an AC unit, I hired a private security guard for me in order to finish the repairs. How far do I go
Well,
to
first
keep
of all,
her safe?
I'm worried about the safety of you. Are you driving right now?
I'm parked. I'm parked.
Okay, because, oh, I see. So you're holding the camera. It looks like you're moving, and I'm thinking, oh my God, somebody's safety really is in jeopardy.
No,
here.
no, I know better.
Well, first of all, you're telling me that he chased her with a drill in his hand? And does she
Correct.
have any reason why he would have chased her?
No, she gave no reason, but I also do have a video camera on the property, and I told her I have no footage, which she replies, oh, he erased the footage. And I said to her, he can't erase it. I'm the only one that can
Okay, so
erase.
I would confront her and tell her, look, we've done the video surveillance. There was no gaps, and I'm the only one who has control over it. So what you're saying is a patent lie. And quite frankly, this might be even grounds for eviction. Accusing someone of something and calling the police, you're creating a nuisance. So I would suggest, Ms. Tenant, that you keep your mouth shut with regard to this issue. Otherwise, I am going to bring forth an eviction. You can't make a false police report and start making these claims against your people on the property. That creates a nuisance.
That's how I feel, but I thought if I have to go in front of a judge, I put my best foot forward.
And you, I think you have good feet.
With the security guard, yes.
Yes.
Okay.
Well,
Okay.
yeah, but I think that you just have to act reasonably in this situation and really confront her, saying you're making up these charges. My manager had no reason to chase you, and there is no other. You have no witnesses to this, but we have a great witness. It's called the video surveillance, and you just made this story up, and you're caught now. Okay.
Yeah, I did offer her the security deposit back and a month's rent because I just obviously want her gone.
Yes,
right?
very good business decision on your part, but of
Yeah.
course, the nut decided not to take your offer.
No, and
Of
exactly.
course.
Now we know.
Okay, thank you.
Appreciate it. Thank you.
And let's do a quick back to Garber. Let me see if Garber's around these days. Garber, you there? Nope. Okay, then we're gonna lower your hand, young sir. And we're gonna move on to
Yes,
Sal.
I'm here.
Oh, good. You were
I had a slow finger.
okay. Yes, you did. We called on you before.
I kept poking my phone, but nothing happened.
Sometimes that is troublesome. Anyway, young sir, how can I help you?
Are you familiar with SB 602?
You'd have to, I'm not with the number, but what is it? Can you tell me a little bit about it?
It's the section of the law now that provides landlords an easier time securing protections against trespassers.
No, in fact, I opened up the show with that. I'm not familiar with that. And we were talking about how Florida just passed a law that will allow landlords to have they can ask the police to just throw them out without having to go through a long procedure. Has this bill passed that you're referring to?
Yes, and let me give you a little background under it on it. Under the current law,
You said SB 602?
Yes, it's Penal Code Section 602, I guess, but it was SB 602 when it came up and was passed. Originally, when it was passed, it only gave you 12 months worth of protection, which I'll fill you in on in a second. But effective January 1 this year, it extends to 12 months. And under current law, property owners have who have a problem with trespassers can submit a no trespass law letter, commonly referred to as 602 letter, to local law enforcement. These letters, once filed, remain in effect for 30 days, giving law enforcement a mandate to remove the trespassers from the designated property. Now, this has been extended to 12 months this year, effective January 1.
Yeah, I'm kind of looking at it now, but that would require that the homeowner or the apartment house owner first file with the police department. Is that what you're saying?
Yes, and that's going to lead to my question. You have to go to the police and file that 602 letter that I mentioned. So that leads me
so
to
I guess that might be, and I'll have to review that, but I guess that might be a good thing. If you have any vacant units, immediately go to the police with the documentation that this is a no trespassing unit, and then maybe they'll do something with you.
Well, and the reason that I want this, I have some single family homes in Encino, and whenever I have a turnover, since I don't have a manager on site, I'm concerned about squatters. And so I went down to the local police station trying to get some information on what they would like in the 602 letter, and they had no idea of what 602 AB 602 is all about.
Yeah. Well,
so what should I do? Educate them?
Well, I would hand them a copy of the law and tell them to check with the city attorney's office. Okay, that's what I would do.
Okay, thank you.
All right, good information. I'm going to check that out, and that might be a something I'll talk about in upcoming shows. That if you do have a vacant unit, race down to the police department and give them your 602 letter, so that you're not worried that somebody's going to take over your building.
I think you should do it
putting an alarm
beforehand.
on it probably is the best way to go, though.
Well, but then you got squatters without that, and then you have to try to get the squatters out.
Well, yeah, but if you get your alarm that goes off, okay, then they're just going to be moving in. It's going to be obvious that the police are going to throw them out.
Oh, okay.
All right. Well, thank you very much.
Thank you.
All right. And let's see. Let's move on to Salvador Salas. I'm going to ask you to unmute yourself. There you go.
Hi, good afternoon, Mr. Block.
Hi. I think you need to speak up a little bit.
Oh, okay. Sorry about that. So I've used you guys in the past. You guys were great, defaulted the tenant and got them out. So it's a single family residence. It's split up, bottom floor, top floor over in Watts. It's a new build in 2006. So currently I'm renovating that unit upstairs, and I have a tenant downstairs in the unit. And so this tenant, he's gotten a little out of control and, likes to start yelling and stuff. And he's just making up all these mold stories, saying the floor is wet, and he's just going on. And so he currently owes me, well, now actually currently he owes me $4,000, but he owed me $7,000. So I gave him a 3-day pay or quit, and he gave me the $3,000. So he went to an attorney, and the attorney is saying to basically that the place is uninhabitable due to the mold. I had my insurance company go out there, and they basically were like, well, you need to air it out. It's too humid in here. And they do have the windows closed all the time. So there's a little bit of mold on the window sill. And then he's saying there's some stuff on the floor. He's claiming it's mold, but it just looks like dirt and dust. But definitely under the kitchen cabinet, there is some mold there. And there was a leak there, which he just told me about.
Well,
So
I'm let me to interrupt you. You got to take care of this immediately. You've already gotten a
Yes.
letter from an attorney, so get yourself some mold remediation and let them give
Mold
you
remediation.
their recommendations as to how to prevent this in the future.
Okay, so mold remediation. Okay, yeah, because I had the
Immediately,
leak.
like today.
Yes, definitely. Okay. And do you have any mold recommendations for the remediation?
You're the second person to ask me that, and the
Oh,
answer
yeah.
is I don't. But if you go to
No.
the Apartment Owners Association, their website, and look at their magazine, there's a lot of mold people in there. And generally, the people who deal with the Apartment Owners Association are very reputable.
Okay, so also, so I served him the 3-day pay or quit, and like I said, he paid me 3,000. So it looks like I need to fix this since he's retained a lawyer. So how long till I could serve him another 3-day pay or quit?
Well, I would take care of the mold situation
Yes.
first. Once
Take care
that's
of the mold.
done, then we can enforce your rights with regard to the rent. But that's just got to be done. That's like a Monday or a Tuesday type situation.
So, but do I have to wait till next month since I served him one this month, or could I just serve
You
him as
don't
soon
have to
as-
wait, but I'm just saying in the face of him claiming mold and now you're going to make a demand for the rent, I don't think that makes any sense. Get the mold situation taken care of, then we can make a demand for the rent.
Okay, real quick question. You said you could raise it in the city of LA 10%, 10% for the rent, and that includes what utilities if you pay for utilities?
Okay, no, I did not say that. First of all, this is a house, correct?
Yeah, it's a single family residence. Yes.
And there's only one house on the lot.
Yes, but it's split up first floor and second floor.
Oh, okay. So you have a duplex. No, so you're under LA rent control, assuming the property was built prior to 1979, and you're only entitled to a
built in
4%
2000.
renting. I'm sorry, what?
Oh, it was built in 2006.
Oh, okay.
But it
So
is
you're under,
it's
so you're
it's
under, let me see.
single family.
It's not a single family because you're telling me there's 2 units in this one house. Right?
But technically it's a single family. Yeah, it was built
You
that
can
way.
call it whatever you like, but you've got 2 sealed off units.
Okay, yes.
Yeah, in other words, I can't get in. So if I'm in one unit, I can't get to the other unit unless I walk outside and go to a different door, correct?
Yeah, not necessarily outside. Yeah, because it's kind of all enclosed, one door to enter.
Right, but again, you're going through, there's 2 separate units.
Yes,
Okay.
yes.
And on that basis, you're under statewide rent control. So that would be an 8.8% rent increase, and it has nothing to do with utilities. So it's just 8.8%, and you would serve a 30-day notice.
30-day for 8.8. Okay. Okay. Thank you. Appreciate it.
All right, you take care. And let's move on to Harold. How are you, Harold? Say hello.
I'm good, Dennis.
I am good too.
Love this show. Can you hear me?
Yes.
Okay, good, good.
And we have no advertisements. How do you like that?
What's up with that?
Yes.
Isn't there an event coming up in a couple weeks?
Yes, I talked about it at the beginning of the show.
Right,
I'll say
I'm going
it
to
again.
that. I'm going to that for
But,
sure.
yeah, Los Angeles Convention Center. That's
Yeah.
March 20th, Wednesday. All you
Yes.
got to do is pay for the parking. Otherwise, the event is free. It's sponsored by the Apartment Owners Association, and I'll be speaking at 1:15. So any of my Zoom people, please come up and introduce yourselves, and I'd love to talk to you.
Awesome. Okay, so here's where I'm at. What if you have the person is making noise, you send him text from time to time to turn it down, and every so often because he gets drunk a lot, he gets noisy again. In the real world of LA, how can you get that person out? Because I know he gets a chance to change his ways, I guess, once you send him a notice, right?
Not really. I would send him a warning letter. And then if it continues, then we would serve him with a 3-day notice to quit based on nuisance.
Okay, so let's say 3-day notice, like quit making noise. And then
No. It's not a 3-day notice to perform or quit. It's 3 days, get out of my property. But I would first serve him some warning letters asking him, look, you're making noise, you're disturbing other people, stop it. Send him another warning letter. Now, after the 2 warning letters, if he continues, now it becomes a nuisance. A nuisance isn't something that we give him a chance to correct. A nuisance notice is a 3-day notice to quit. Get the hell off my property.
okay, that all sounds super too good to be true. No, what about the witnesses? Can it be one versus one, or you need another person?
You can do one, however, it's better to have more than one.
Okay, okay. And then as far as any records, like if it's uncontested, there's no issue. But if it is contested,
Then
then
I'm gonna need to have these witnesses come to court and say how their lives are miserable.
Okay. To be continued. This is really good.
All right, take care, Harold. Okay, we are moving now to an iPhone. If you're really on your iPhone, then you need to hit *6 to unmute yourself if you're on an iPhone. Otherwise, just hit the unmute button. iPhone, are you there? I don't think so. We're going to move on. Last chance. Let's move on to Jayun Pao. I know I butchered your name. Pao, there you go.
Hello, Dennis. Can you hear me?
I can.
Okay. It's Pei last name. It's okay. My name's been butchered like so many times. I'm used to it. No offense.
I think I butchered it on this show before.
You're not the only one, Dennis. My question is, we have like a few different units, different places, and my focus on the contract, original lease, which was done like years ago. And right now, each of those units have like only a single name on the contract, and they have a bunch of occupants, like their relatives, whatnot, living with them. And my question is like, okay, in the future, in case of the person that's on the lease like passes away, so what are my options with dealing with the occupants of the units?
Okay, well, first of all,
go ahead.
What city, please?
I got one in Los Angeles and one in Cerritos.
Okay, so let's take Los Angeles first. So when the rental agreement only has one name on it and one occupant that's allowed, correct?
But this is original with my father, and my father had like, actually he had two people on it, but then I got the letter saying that, okay, please take the other person off. So there's only one person on the lease itself.
Okay,
But then,
when did these extra people move in?
Hard to say. I mean, this is before I got involved. I mean, I think it was, I would say more than several years ago.
Okay, so you have an option of when the original tenant moves out under a law called Costa-Hawkins, you have the right to raise the rent to market level to the remaining people, as long as the original tenants have all moved out, and then people who joined the tenancy thereafter would now be subject to a rent increase to market level.
Oh, okay. Okay. Yeah, because I was
think
wondering
the same, of course, would be in Cerritos. You're under statewide rent control. And if the original tenant moves out and you've never taken rent from, quote, the strangers, then you have the right to evict or raise the rent to whatever you like.
Oh, so I have the option to either evict or raise the rent. But in my case, I'll
As long
probably
as
raise
the
the rent.
original tenant has moved out.
Right. Well, that includes being passed away, right? Deceased, right? Of course.
Correct. Moved out
Okay.
vertically or horizontally.
Literally. Okay. All right. That's it. Thank you very much, Dennis.
All right, I'm going to move on. We're going to do one last call. I'm going to take David. I'm going to ask you to unmute yourself. I'm going to end it a little early because I got to get downtown to that Laker game. So, David, I'm going to ask you to unmute yourself.
Hi, Dennis. A quick question regarding returning of the security deposit. For example, I have a person who is being paid on monthly basis, but my question is, if I do a cleaning fee or other fees for, broken stuff or stuff like that, if they ask me, okay, how did you come up with that? Can you show me your itemized bill? Well, I don't have an itemized bill because this guy works for me on a monthly basis.
Yeah, but you have to do an hourly chart and a wage. So whatever his hourly rate is, what you pay him, and you'll list the hours that he worked for you to correct this problem. So maybe he's getting $25 an hour and he worked 4 hours, that's $100. So you just give him, which is receipts, make up your own wage or bill invoice showing the amount of hours and what he's paid. And that's perfectly permissible. You don't have to go to a company. In fact, for the work that you do, you can give yourself an hourly rate that's reasonable and then proceed forward.
I heard that your rate is a lot allowed when you do the work is a lot less than when you have a contractor, for example.
Well, I
Same-
mean, it's what the reasonable rate would be. If a contractor obviously is going to get more money than a person who's not a contractor, so.
I understand. Thank you, Dennis.
All right, well, thank you. I'm going to end it here, ladies and gentlemen, but I do appreciate everybody joining. I will have the video of this up tomorrow, not today, as I usually do. Once again, don't forget Wednesday, that would be March 20th. I'll be speaking at 1:15. Come down and meet me. And everybody, I want you guys to have a great weekend. And what else can I say except go Lakers?